Senate Republicans refusing to delay Brett Kavanaugh's hearing on Monday morning, giving his accuser until 10 o'clock tomorrow morning to decide whether she will testify. So what happens next?
Fox News senior judicial analyst, Judge Andrew Napolitano, is going to join us now. Do you think she'll decide, okay, I'm going to speak on Monday and then get all my information in by tomorrow at 10?
Well, if she does that, the Senate rules require that they know by 10 o'clock on Friday, that, 48 hours ahead of time. And Senator Grassley is enforcing that rule. But here's the dilemma faced by Judge Kavanaugh. There's a basic rule of thumb, and this makes sense whether you're a lawyer or a judge or in a schoolyard. You don't deny something until you've been accused of it, until you can get your hands around the accusation. Right now, we're dealing with an accusation which is hearsay. Dr. Ford spoke to a reporter for the Washington Post. The Washington Post printed what, in her view, is an accurate version of what Dr. Ford told her. Should Judge Kavanaugh be responding to an allegation recounted in a newspaper, or should he be responding to the person who actually says he attempted to harm her? In the real world, it would only happen with the latter. In the real world, if she didn't show up, if she didn't articulate her allegations against him, there'd be no obligation on his part to respond. Now, he's dying to say, I don't know what she's accusing me of. I wasn't there. It didn't happen. But it is dangerous to deny before, particularly under oath, before the allegation is made. So I have a suggestion, if I may, for Senator Grassley and company. Subpoena her.
Whoa.
She decided to go to the press, maybe reluctantly. She voluntarily spoke to the Washington Post.
Provide the therapist notes.
Correct. If they subpoena Dr. Ford, if they subpoena the therapist notes, if they subpoena Dr. Ford's husband, who, according to Dr. Ford, was there when this incident was recounted, then they can interrogate them.
Well, could her team still say, all right, we will respond, we will show up to the subpoena, but first you've got to do an FBI investigation?
When this happened in 1991, the Senate Judiciary Committee did send the FBI to interrogate Anita Hill. And when Senator Specter cross-examined Anita Hill, what did he use as the basis of his cross-examination? The FBI reports, because the testimony she gave to the committee differed from what she gave to the FBI. So using the FBI as a neutral gatherer of facts is not necessarily going to hurt Judge Kavanaugh's case. It might actually.
And why was the letter that she sent that made it to Dianne Feinstein's desk, why was that letter given to Grassley redacted? All of this is public now. What is in that letter that had to be redacted?
I think her name was redacted at the time. Senator Feinstein says she got the letter but was told, don't do anything with it. That's a rational explanation for not doing anything with it. My view is Senator Feinstein had an obligation to share that letter with the White House and with Senator Grassley. We wouldn't be in this mess if this had been addressed at the beginning of the hearings rather than after they were over.
Lastly, when Anita Hill was years, this is 3+ decades.
Yes.
You can't tell the FBI to rebuild a high school graduating class. That's what you're asking them to do. Look at the yearbook and try to see what they look like and where they are now.
Well, we're not asking the FBI to go through the yearbook. We're asking the FBI to interrogate her and then to share those notes with the Democrats and the Republicans in the Senate.
How do you verify her story? That's what the FBI would do.
She would have to corroborate her story. And look, if she testifies and he testifies, what are the rules? Does she have to prove her case? Does he have to disprove her case? There are no rules. It's going to be, what is the impression at 5 o'clock Monday afternoon? Which one is more likely telling the truth?
Exit question. Would what we know so far about this case, would that stand up in court?
Absolutely not. It's too ephemeral. It's too indefinite. It's too, I don't remember.
Right.
Most judges wouldn't even let a jury hear it.
All right, let's clear the courtroom.
Okay.
Thank you very much, Judge. Thank you, Judge.
Let's see if Chuck Grassley takes you up on your subpoena idea. That's something.